Thanks for joining me. This is the Law Office of Don Dennis, where I discuss the laws and how they affect your business deals, whether you do them online or in person. And the goal is to teach you how to get paid for your ideas and your brand name, because these are your most valuable assets. And also, we teach how to prevent from being taken advantage of. And it happens too much, and we're here to stop it. As always, there is no attorney client relationship formed between you, the viewer, and my office unless there is a signed agreement on file. This presentation is rated R for real and not PG for playing any games whatsoever. So let's get to it. Tonight, we're talking about who will get the last laugh. As you can see, Monique and DL Hughley have been going back and forth. They've been getting into it concerning a show that they did recently in Detroit. And the issue is, from DL's standpoint, he had a deal memo that laid out him being the headliner along with several other terms. And Monique's statement is that she had a performance agreement, and she says her performance agreement was signed. So what exactly are we talking about? What are we talking about? What is a deal memo? What is a performance agreement? Let's get into that. Are these agreements ironclad? Does it matter that they don't have a signature? Let's get into this. So, in general, in Hollywood, the process by which deals are done can be kind of long, and it's not always a clear-cut situation. So, first, there might be some initial discussions between people, and they're talking like, hey, I want you to be in this film. I want you to do this show. And this is how I kind of think it should go. This is what I like. This is how much money I'm thinking we could make, and how much you would be paid, and how much I would be paid. And so there's a lot of talk and a lot of discussion. And it's often done orally. A lot of things are not reduced to writing. And then from there, it might get to the next step, in which a letter of intent or a memorandum of the understanding that's been going on between the people will be drafted. And then that sometimes will have the basic terms. Some of the negotiated basic points might be in that. However, it oftentimes has not been reduced to writing. It's all in still a period of negotiation. And why is that? Why don't they just, it's Hollywood, there's millions of dollars at stake. So why not just put it in writing? Why not just stop all the games and just write it out? This is what you want. This is what I want. We sign it and move forward. Well, there's a few reasons behind that. First of all, a lot of times in movie deals or entertainment deals, there's a high risk of failure. There's not a success that a stadium is going to be sold out. There's no guarantee that everything is going to go according to plan. So when you have investors that are behind these deals, promoting these deals, they're a little hesitant of putting their money forth because they don't want to lose out. So they might not be willing to commit until a star has completely signed up. And stars aren't always to commit until they know things are going to be certain, because they don't want to mess up their calendar and other possible engagements and events where they could be making money. So there's a lot of things going on behind the scenes. Now, usually in this situation, let me back up. In this situation, D.O. Hughley has produced on Instagram a copy of his deal memo showing major points in the memo. His memo, if you take a look, shows the date of engagement, who will be the highest paid, travel accommodations, a deposit, who has the approval of lineup, and who has approval of the running order of the show. And he states that he was in control and had approval of all of these things. But on the deal memo, I did not notice a signature, which is common. It is very common that these deal memos are usually not signed, and they do lay out some of those main things, such as compensation, the performer's role, and other compensation contingent upon how things go. So that's common. And so it's not strange that he has a deal memo that wasn't signed. However, Monique's argument is, look, I have a performance agreement and it's signed, and I have initials on each page, which is a tip. If you're looking at making sure you have a contract and making sure it's going to be enforced and there's no misunderstanding about what's on each page, besides just having a signature page at the very end, it's extremely helpful to have initial columns at the bottom of each page. Now, I can't break out and decipher whose initials those were. However, on the document that she showed on Instagram, there are some a column for initials, and those were allowed to be presented on the agreement. And again, Monique only presented a one-page agreement that showed some initials. However, some of the issues that we're talking about now is, was that agreement binding, or was that deal memo binding? How do we know if it's binding or not? I mean, it's not signed, at least the one that DL showed. It wasn't signed. It's just something that has some points on there. So the way that courts look at this is courts will say, is this such a one-sided agreement that it doesn't necessarily make sense that someone else signed it? Did they deliberately leave important things out? Does it show that there was a mutual agreement? You can't have a contract if two people don't agree to what's going to be done, when it's going to be done, and approximately how much money is going to be paid for that. So those are some of the essential terms that you're looking for. You want to see if there's a mutuality of agreement. Also, did everyone understand what the whole contract and performance was about? That is key, because if people are not on the same level of understanding, that is extremely problematic from a court standpoint. And you have to think about it. A court or a jury is composed of just a bunch of people that are sitting around trying to make sense of what someone else did and trying to determine if it makes sense and if in fact you can explain and determine enough from the document that they present, if in fact they have a document. And then lastly, let's say there was no signed agreement and there was just a deal memo. How did the people behave after the deal memo went out? Did they do the things that were actually listed on the memo? Because if so, despite the fact that it wasn't signed and it didn't spell out everything, if everyone acted in accordance to what was on that paper, it kind of looks like there really was a deal. So in this situation, we don't know, but we're going to have to find out later. Now, what are some ways to get around this to protect yourself so you don't get caught up in situations like that, where you don't know if you just have a deal memo and it wasn't signed, or in fact, you have a contract? A lot of times in Hollywood and entertainment deals, whether Hollywood or New York, when you have a lot of negotiation going on, what people will do is say, well, you know what, we're negotiating, but the negotiator for one client could send over a reliance letter. And it says, hey, this is what I understand and I agree to perform, or my client agrees to perform or star in this show or movie or TV deal based on what we last discussed, and therefore I'm going to rely on that and we can move forward based on that. And if there's no dispute, that might be great to move forward with. However, if the other side, that wasn't quite their understanding, they might send back a counter reliance letter saying, hey, well, yeah, we agreed to certain things, but actually our understanding was this, so we can move forward based on this understanding. And that's very important, because that way you're flushing out important details, because people's memories fade. People forget. They may have thought something, but they were dealing with so many different things. They forgot to include something. And by not having any type of reliance letter or anything written down, it makes it extremely hard to enforce. Another legal issue that can come up here is if, in fact, another way to get rid of legal issues to some extent is to have in the contract an integration clause. And the integration clause says, look, regardless of what we negotiated, regardless of what we talked about, other emails and all these different things that were going back and forth, at the end of the day, only what was put in this signed agreement is what we agreed to. So only the final contract that we sign off on is what we are bound by and what will be enforceable. Everything else that we talked about, all the talk that we had at the industry parties, all the talk that we had on the phone and text messages, unless all that information made it into this contract, it's not binding. And that is extremely helpful to have an integration clause, because it prevents things from being contradicted. And again, it reduces the possibility of confusion. So these are important tips. Now, in this situation, we're going to find out, because each side, whether it's DL or Monique, they only produced a part of it. So we don't have the whole document. We might have all of the deal memo, because it appears at the very bottom, it says 1 of 1 page. So there's only 1 page, but Monique produced one page of her performance agreement, we didn't see all of it. So if in fact that was signed and executed by the promoter or by DL or whomever else she was doing business with, that is a sure telltale sign of what exactly the agreement was. As always, the only way to truly know that your deal is ironclad and solid is to get it in writing. And even in circumstances where it's not the custom and it's not, easily accessible and people acceptable, where everyone wants to write things out because, hey, let's not be too formal. We all understand each other. We all get along. It doesn't help in situations like this. So you always want to get a great understanding with whomever you're doing business with to get things in writing. It's kind of like if you don't have it in writing, it's like seeing that sign where you go into a store and they're mopping and they have that little yellow triangle sign on the floor and it says it's slippery or slippery when wet or wet floor. You are walking on a wet floor with some shiny dress shoes on, trying not to slip and fall. And actually, if you're moving forward with a very expensive or very advantageous contract, you're running across this wet floor, trying to make sure you don't fall. But if you do, you can fall and hurt yourself real bad. And it's the same thing with signing these type of contracts and not having the adequate protections and safeguards that I discussed, such as an integration clause, such as getting things in writing and getting a great understanding between you and the party you're dealing with. I encourage you to like, subscribe, and hit that notification bell so you can always stay up to date with videos here that will help your business succeed and help you stay out of trouble. Thanks for joining. Have a great day.